Ghana Tonight is brought to you by
Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.
Sasso insecticide spray and coil.
Good evening, welcome. This is Ghana Tonight. We're live on news about Desawe Kanda, also live on TV3 Ghana on Facebook, DSV channel 279. We're all across the world on 3news.com. Tonight, as we get into the matters unfolding right now, the Ghana Bar Association stands against the suspension of the Chief Justice, Gertrude Tokono, demanding the immediate revocation of the said suspension, amongst other demands. We'll hear the full complement of the GBA's demands and some reactions to it shortly. We continue to stay on this steam on this matters of illegal mining, unpacking the seeming controversy surrounding the purported release of some seized excavators in the Ashanti region, raising concerns amongst anti-Galamsey crusaders. Stay with us. The Kumasi Metropolitan Assembly has been clarifying a number of things. Also, we have an update on the ongoing mediation of the Bawku conflict by the Asante Otumfuo Say to the second for you. Stay with us, as always, here on Ghana Tonight. And we are also going to touch base with Ablekuma North. Don't forget, the people of Ablekuma North do not have any member of parliament representing them in this 9th parliament. Let's not forget that too quickly. We'll give you an update on it, because there's something as well in the works. As always, you're an integral part of the conversation. Let's hear from you. The hashtag we're using is Ghana Tonight on Facebook and on X. Let's get talking. Let's settle for Ghana Breeze.
The Ghana Bar Association (GBA) has called on President Mahama to urgently disclose the basis for his decision to establish a case against Chief Justice Gertrude Tokono, which led to her suspension. This call formed part of resolutions from the GBA's recent media conference. The association also demanded the withdrawal of a directive by Acting Chief Justice Bafo Boni on case assignments and called for greater use of technology in judicial processes. President John Mahama has launched the Ghana Medical Trust Fund, a flagship healthcare initiative aimed at reducing the cost of treating chronic illnesses. Otherwise known as Mahama Cares, it will provide financial support for persons suffering from chronic diseases such as kidney failure, cancer and heart conditions.
Today we're launching more than just an initiative. We're launching hope. Hope for thousands of Ghanaians living with chronic diseases. Support from the fund will be based on formal applications, carefully vetted, and will focus on costs not currently covered under the NHIS. The fund will operate as an independent statutory trust, governed by a board of trustees and supported by a dedicated administrative secretariat.
Meanwhile, health sector players have commended government for the Ghana Medical Care Trust Fund initiative. They, however, intensified calls for government to support the training of more healthcare specialists for a comprehensive role and distribution of the resources of the Ghana Medical Care Trust Fund initiative across the country.
Chronic care is not just what every doctor does. Most of chronic care people are looked after by specialists. And we need to increase the number of specialists out of the urban areas. There are not too many specialists. So, and it can be done.
Very soon, if we do not take care, we will not have the healthy population that will work in the country. And that is why we find this as a timely intervention. Of course, we acknowledge other interventions that have been tried in the past by previous governments for dialysis and others, but this is comprehensive to deal with those chronic conditions.
The Ghana Water Company Limited in the Eastern region is currently producing only 1 million cubic meters of water daily, far below the expected 3.5 million cubic meters. According to the Eastern Regional Director, Engineer Paul Cletus Akpanya, the 2.5 million cubic meter shortfall is due to polluted intake sources caused by illegal mining activities and the use of outdated equipment.
About a month ago, by evening when they were going to sleep, there was water. The next morning, the intake was completely dry. When they moved, they went to pack bamboo in the river, block the water so that they could have water to wash whatever. Because the plant is not designed to treat that quality of raw water. So we have to bring in another system where the water will settle before it now goes into the flocculation, coagulation, sedimentation process before we can move out. So we are now working on what to do. It's a bad situation.
The Executive Director of the Chamber of Petroleum Consumers, COPEC, Duncan Amwa, has announced an impending reduction in fuel prices effective Thursday. He attributes the drop to favorable international market trends and the relative stability of the Ghanaian cedi. Duncan Amwa, however, cautioned against immediate adjustments in transportation fares.
You should see pump prices decline marginally effective Thursday, Friday morning. That has led to calls by a section of Ghanaians for reduction in transport fares. We think that we should hasten slowly. Fuel prices as we speak, although have gone down, are still above the 14 Ghana threshold. If we force the transport operators to go down on their fares, we are simply telling them to go up again if tomorrow you wake up and the fuel price has gone up again.
Oh, it's more news on 3news.com. Make some time and visit 3news.com. This is Ghana Tonight. Coming up, the Ghana Bar Association stands against the suspension of the Chief Justice, Geto Tokono, demanding the immediate revocation of the said suspension, amongst other demands. We're going to be getting into the full complement of the Ghana Bar Association's demands and some reactions to it. And in fact, if you've been following the news, you'll get to know that this is not the first time that the GBA, at least for the last 3 days, there was this suspicion of whether or not what we were reading on social media especially was indeed true, because there hadn't at the time until now been any official statement of communication from the Ghana Bar Association after the Bar conference over the weekend that they had indeed issued this particular statement and resolved based on their communique after this Bar conference that they were against the suspension of the Chief Justice as in accordance with Article 24610A of the 1992 Constitution. Now, but so exactly what are they saying? What are they asking for? Now that there's an official statement from the Ghana Bar Association after the Bar conference confirming what we have been reading all the while, calling on the President to, as a matter of urgency, release what constituted his decision that led to the establishment of a cause, or as we say, a prima facie case against the Chief Justice, Geto Tokono, resulting in her subsequent suspension. The association's call to the President is part of resolutions, in fact, that they made at the just ended mid-year conference over the weekend. My colleague Dennis Baberi-Wadam, who is a private legal practitioner in good standing. Essentially, you're a member of the GBA, is it not?
I'm a member of the GBA.
Okay, let's get in. But you were not at a Bar conference.
No.
I know you were attending to other matters.
No, I was in the Alfred.
Of media general concern. But let's get into the statement. What exactly are they asking for?
Well, so this is now official because over the weekend there had been some conversation about the GBA having passed a resolution of some sort and making demands. But I think at the time over the weekend, the one topical thing that was up there was the fact that the GBA was demanding the revocation of the suspension of the Chief Justice. Now it is clear that indeed on the said day, which was on Saturday, April 26, the GBA indeed passed a resolution, amongst other things, demanding the suspension of the Chief Justice. And clearly, the argument that the GBA is making, or how they arrived at the conclusion, is to the fact that, I mean, in their view, the decision to suspend the Chief Justice, it's discretionary, and the President, in performing such a discretionary function, ought to comply with Article 296 of the 1992 Constitution, which provides a guide as to how discretionary powers should be exercised. It is the view of the GBA that the President, who is not a judicial officer, he's not a judge, ought to have published some instrument of a sort, either constitutional instrument or a statutory instrument, specifying how that discretion was exercised. And to the extent that that wasn't happen, I mean, that did not happen before the suspension of the Chief Justice, the GBA is of the view that the said act was unconstitutional. And they didn't mince words in saying that. They described the act of suspending the
suspension of the Chief Justice was unconstitutional?
Yes, as being unconstitutional.
I see. And on what basis did they describe that as unconstitutional? Because consistently, in their view, we here on Ghana Tonight with you on the magic wall have gone through the Article 296(10)(a) that specifically stipulates exactly what the President has done, is it not?
Yes, they don't dispute that. And Alfred, even if you recall, on Thursday, which was on the 26th of April, 2 days after they had issued, they passed this resolution, the GBA issued a statement, and in that statement, they made mention of how they were following the process and how they were aware of the processes that were outlined in Article 146. They did indicate that they were only calling on all persons who were in this process to heed to Article 296. So they themselves expressly mentioned that they were aware of the process under Article 146, 6, 7, 8, 9, and 10, which includes the suspension, of course. But they were only cautioning that care should be taken that full compliance be given to Article 296. So in hindsight, if you look at that statement, then you can understand how this resolution came about, because the reason for declaring the conduct of the President, and I say declaration because that's what it appears to be, that it is unconstitutional, is because in their view, it does not conform with Article 296, which guides the way discretionary powers should be exercised according to the Constitution. To that extent, according to the GBA, they deem that as being unconstitutional. Now, having said so, they're also demanding that there should be an enactment of clear regulations to guide Article 146, proceedings on removal of justices. Now, Alfred, even though they did not say more, knowing what we know and how we got here, and knowing that there are pending suits at the Supreme Court regarding the removal of the Chief Justice and seeking interpretations, it is clear that indeed there has to be a clear path as to how to navigate Article 146. A typical example would be the question of whether or not, if the President receives petitions for the removal of the Chief Justice, the first thing the President has to do is to forward the petitions to the Chief Justice and get her response before the consultation with the Council of State, or the process can be ongoing before the President now gets the response of the affected Chief Justice.
I see.
That is a question that hopefully in the coming days the Supreme Court will answer. There's also the question of timelines. You recall that the Chief Justice, when she wrote the letter to the Presidency asking for the petitions, she was asking for 7 days.
Yes.
The President gave her 10 days. The question is, how long should it take for one to respond to such petition? So, I mean, even though the GBA...
But in the absence of all of these regulations and the constitutional instruments that the GBA is asking for to guide the execution of Article 146, specific 10A, the President can only work with what is existing, is it not?
Precisely so.
So, has any wrong been committed?
Well, I do not see the GBA on that particular one to be faulting anyone or to be suggesting that a wrong has been done, except to say that it's a demand they are making.
Okay.
And possibly this can be taken into consideration amongst other things moving forward, if there's a need for a constitutional review perhaps, and if we begin to look at the reactions that are coming through from senior lawyers, maybe that will fit into that particular conversation. Alfred, it does not also end there. The GBA also wants the immediate release of the decision establishing the prima facie case against the Chief Justice. What they are in essence saying, that the President should show us how he, together with the Council of State, arrived at the decision that a case had been made against the Chief Justice for which she must answer. They are saying that it should be in line with established precedents. The GBA does not mention what the precedent is. But then again, if we follow discussions in the last few years and times that we have come to a place like this, we recall somewhere in December when Professor Bawku Asare petitioned the President for the removal of the same Chief Justice. There was a statement from the presidency indicating how that petition was dismissed.
But that was after the fact, is it not?
That was. So, yes, after the fact. So, what it means is that at the end of it, a decision was made whether there was a case or not. That was communicated.
After the process had ended?
Of course, because there was no case made, the process had to come to an end.
Okay.
But that's a good point you're making. Because the arguments that are coming, and of course, there's the Supreme Court decisions to that effect as to when the proceedings can be made public. You know, when we work through the process, part of the process is that the whole proceeding must be in camera. So that's the argument that others are making, that, I mean, if the process is supposed to be in camera, how then do you expect that the President will make such revelations at this point when the process is still in progress? There's also the last one, which the GBA is condemning political commentary, and they say that that undermines the judicial independence and then a pledge to protect the judiciary from such interferences. There will be an interesting reaction to this particular point because somebody has taken issue with this. Because if the GBA is condemning political commentary because in their view it's prejudicial, then why then is the GBA already declaring what the President had done or has done as unconstitutional?
Let's seek an answer from the public relations officer of the Ghana Bar Association, lawyer Xavier Koji, is joining us on the telephone. Good evening, lawyer Xavier Koji. Thank you for joining us.
How are you, sir?
I'm well, thank you. Now, so why are you condemning political commentary? Let's start from there. But then again, in the same statement, you go ahead to express your opinion of the President's decision in accordance with the Constitution upon the advice of the Council of State as unconstitutional.
Thank you very much for the opportunity. I think what we meant by that is that, you know, there were allegations or statements that before the sitting president, as we have it now, became president on his campaign trail, he made certain comments that when he won when he became president, he would remove the Chief Justice. I think I've heard something like that. Then the other side to counter that, okay, now that he started a process, when it also come in the future, we'll do same. Those are the comments that we are referring to, that they are prejudicial, and we don't want to hear them from both sides. Probably before we didn't say it this way. That is what we meant.
But well, that's what I'm saying, that in this same statement that you raised this concern, you are also essentially making comments and expressing your opinion about the President's decision, which is consistent with the Constitution, as you have acknowledged that he's done nothing wrong. So why are you condemning something that you are condoning in this same statement?
What we mean, I believe you are referring to where we said the President's suspension of the Chief Justice is unconstitutional.
It's unconstitutional, yes.
I believe that's what you are referring to.
Exactly so.
Let's put it in the context. The reason we put it that way is that yes, the President has every right to exercise his discretion to suspend the Chief Justice per the Constitution. But Article 296 also tells us how discretion should be exercised, to the extent that we sitting members who were at our conference were of the view that in this particular instance, relative to the suspension of the Chief Justice, the President ought to have caused a publication of regulations in the nature of constitutional instrument or statutory instrument before going ahead to exercise that discretion. So it's not as if we say that he has no right to trigger the process.
I see. But is it in your place as a Ghana Bar Association to declare the President's act in accordance with the Constitution as unconstitutional?
I think that we are not doing this in our capacity as a judicial authority. Many times you hear people say, oh, this is unlawful, this is unconstitutional. It doesn't mean that those people are they conjure themselves into court. Maybe the cost is coming from us as an association. That is why you're having an understanding. There is no way that we can ever equate ourselves with the court of competent jurisdiction. We are just describing what has happened that is unconstitutional. That is our thinking. So should we even decide to pursue it further, maybe by going to court? I said maybe. That may be the grounds on which we'll be going. That does not mean that we have already decided to go.
But there are others who also hold the view that, yes, this act is constitutional. What would be the GBA's position on that?
Can you take that again?
I'm saying that as you describe that decision as unconstitutional, others also hold a strong view that what the President has done is constitutional. What's the GBA's position on that?
That is the view. If you put two lawyers together, I can tell you on one issue, you have the same position. So that is the beauty of it.
So let me establish this.
At a meeting,
right.
At that meeting, we hold the view that by not publishing the regulations before suspending the Chief Justice, that conduct or exercise of that discretion was unconstitutional. So if there are others who hold a contrary view that, look, irrespective of that, it's constitutional, we will not fault them because that's their position.
But can you point to me?
Even at the GBA meeting, different views were expressed, except that just like it happens at any other meeting, whatever majority agree on, that is what carries the day.
But point to me exactly what the President has done that you describe as unconstitutional. Exactly what has he done?
I think that is what I've just said, that the failure to have caused regulations to be published relative to his exercising his discretion in suspending the Chief Justice. But that is why we say so.
But you agree that the regulations you talk about, in the absence of the regulations that you are expecting to be published, the President can only work with what is existing now, is it not, in the Constitution, correct?
Yes, the President has, you listen to me this way, the President has the right to suspend the Chief Justice. So he has that discretion to exercise. But we are saying that in exercising that discretion, he should have recourse to Article 296, which says that once he's not a judge or a judicial officer, he ought to have caused a regulation to be published in the nature of a CI or statutory instrument. That's what we're saying. So we are not saying that he cannot go ahead, but in go ahead, we expected him to have affected his mind to the provisions of Article 296, which required him to publish a regulation in the nature of a constitutional instrument or statutory instrument before exercising his power to... So
are you saying that the President should have disregarded what the provision of the Constitution is?
The President should have
disregarded what the provisions of the Constitution is? Because as you acknowledge that, yes, he acted... I'm coming to the point. You acknowledge that he acted based on the dictates of 14610A, but then again, not recourse to 296. But specifically...
Yes. So, which means that he had not fully completed the process before he started. Well, it should have concluded by having the published before. So we are not saying that he cannot exercise that discretion, but we're saying that in doing that, he ought to have affected his mind to 296, which required him to publish regulations.
But the dictates of 146 is pretty clear, is it not?
The details of what?
146 is pretty clear on exactly what the President has to do in this particular instance.
He may exercise discretion. Is that not it?
Absolutely. So why do you say the process? You say he started that. I'm coming to a point. You say he started the process, but he should have before. Is that mandatory in law?
No. Excuse me. Hello?
Yes, I can hear you.
Yes, the question again.
Yes, I was saying that you were saying that he started the process well, but then again, at the point of suspension, he should have averted his mind to 296. And I'm saying that is that consistent with the provisions of 146 specifically?
Why not? Because 146 says he may suspend the Chief Justice. The law makes it discretionary. So to the members sitting at that meeting on Saturday, they think that, or they held the view that that situates in the context of 296 relative to exercise of discretion. So he ought to have published or caused to be published regulations relative to the exercise of the discretion he is supposed to be exercised, or he has permission to, or he has the right to exercise under 146. That is the context in which the meeting looked at. And as I said, at that meeting, various people held various views, just that at the end of the day, this is what majority thought should be the meaning of.
Prior to this conference that you GBA had on Saturday, 2 days before that, you had issued a statement describing this entire process is sub judice, and so you were hoping and expecting that the dictates of 146 will be followed as stipulated, and that you're going to watch closely.
Yes.
Then 2 days later, you go for a conference, and then you issue a statement describing this process that you acknowledge in the first statement as unconstitutional. I mean, how do you expect the generality of the public, mortal and mere men like us, to then take the two positions of the GBA?
Yes, I will explain that. The GBA has a hierarchy when it comes to decision making. The first statement that came out within the week was on the instructions of the council and the general council of the bar and the National Executive Committee. The GBA is the highest decision-making body, is the conference of the bar. So either it's media conference or annual general conference. That's the highest decision-making body. So having issued that statement and having gone for conference, media conference, and members of media conferences that look, irrespective of the fact that I issued this statement already, this is the position we want to take. I think that nobody will say that we should forget about that, because that is the highest decision-making body. So if at that forum they agree that irrespective of what we done earlier, this is the new stance we want to take, I don't think they've done anything wrong.
Well, hold on a bit for me, because Martin Pebo is a member of the Bar Association. He's followed this case.
But did he register for the conference?
Yes, but he's a member, is he not? He's a member, correct?
Yes.
So, yeah, I mean, there are a number of... In fact, how many people... Did you form a quorum at this conference to arrive at this resolution?
Yes, because those who registered were a little over 200, and at the beginning, all of us were, every registered member was there. Even some people who came there and registered at the venue. But I must admit, at the time that were passed the resolution, the numbers had reduced.
The numbers had reduced?
The numbers had reduced, yeah. I
see. Martin Pebo, thank you for joining us. I know this is a matter that you've been following closely. You've seen the GBA statement. Xavier Kuji is insisting that, yes, they stand by it, that the president's exercise of this particular discretion is unconstitutional because he should have vetted his mind to 296. I've been asking questions about exactly why they take this position, and he says that to the extent that it's a discretionary authority that has been given to the president, he should have vetted his mind to 296. Is it one that you agree with?
I don't at all. I'm diametrically opposed to what Leonard Xavier Kuji is saying.
Why is that?
Totally opposed to it. It's this matter, more or less, the same question of Article 296 C has been to the Supreme Court, where Amegache versus EC, or no, even the France. Okay, there is France. Ransford France versus EC, where the argument was made that because the EC hadn't published regulations on how they will exercise their discretion, then it means that the elections that were sought to be held, I think that was 2012, will be null and void. That if I said that, hey, to give Saka to oppose such an argument will lead to a nuclear meltdown. Nuclear meltdown. That was 2012. Now, ask yourself, from 2012, what regulations have EC brought? All the other constitutional bodies, what have they done? Right? You even look at AJ Chum versus Attorney General. So for Ekufu and the rest of the bench, when I say AJ Chum versus Attorney General, a case concerning Article 146 proceedings, they said the rules of court committee should come out with fuller regulations, rules that will make the process more streamlined, etc. AJ Chum versus Attorney General was about 20 years ago, 2005, 2006, okay? Till date, it's not been done. About 20 years ago, that's not been done, right? So the Supreme Court has said that the failure to publish the rules as stated in 296 doesn't make the exercise void. It doesn't at all. It doesn't. So let's not kid ourselves. It doesn't make what the president is doing void. It doesn't make it unconstitutional, because the Supreme Court itself has realized that if they were to say so, then society will grind to a halt. So the Supreme Court said there would be a nuclear meltdown. Nuclear meltdown, if you want to say that, for all the public officers who have to exercise their discretion, there must be published regulations and statutory instruments before they do it. So the Supreme Court has answered it. So let's go on, except that as citizens, of course, we have a fair sense of what is justice. If we see something untoward, we'll raise it. The president knows that Ghanaians will not sit down unconcerned. So we are watching. But I think it's far-fetched to say that what is going on or the suspension is unconstitutional. I think that that argument doesn't, there's no merit in that argument at all.
That's what they're saying, that the president should revoke the said suspension on the basis of their argument that it is unconstitutional because 296 was not considered.
That's why I said, so my simple answer is that that answer was given in Ransford, France versus Attorney General, then Parliament. They raised the same thing, that the EC hadn't published regulations on how they will exercise their discretions, etc. And so even we should stop the elections, etc. The Supreme Court said, no, that is not law. That is not law. So this one, I beg to differ from the GBA, my own GBA. And it's curious that the GBA has finally found his voice and is coming here. When Akufo-Addo was misgoverning, we were talking, they were quiet, you see? So it tells you that it's interesting that President Mahama is a better president, he's more accommodating, so now the GBA can wade into such controversial matters. When Akufo-Addo was misgoverning, corruption was at its peak, okay, family and friends, we were on radio, TV, the key points. GBA stood and said, no, they don't want to be involved in such matters. But now that GM is president, they know that he's more tolerant. So for him, they can come and then wade in and make all their arguments. Please, you've seen how our citizens have become very savvy. They've told GBA in no uncertain terms that they are not the conscience of the nation. They lost that position years ago. It's okay, they've come to talk, but they should realize that they lack that authority that they had decades ago. They said they will not involve themselves in national discourse and these political matters, etc. So they should know that they no longer command that kind of respect, that kind of authority, the conscience of the nation. No. Now they ring very hollow. So, but it's okay that they've come in. Let them also, air their views. But they should just realize that it's no longer the GBA we thought it was. It's no longer that GBA. But it's okay. They can have their say too.
I see. Counsel, hold on before. Lawyer, could you, do you lose sleep over this perception that the public has about the Ghana Bar Association because of, you know, the positions you have taken in the past and present about such matters of national concern?
talking about a lot of matters. Even the resolutions that were put in the public domain today were not centered only on the subject matter involving the suspension of the CG or head removal for that matter. You could see that we talked about Bawku, we talked about Galamsey and some other matters. So I would not agree that there is a perception that we've taken a back seat and all of a sudden we want to be on the front bench. I would not agree to that. It is true, it's not everything we can talk about. But once any guidelines we have to talk about.
I see, but you've talked about almost everything that is trending or of national concern in this statement you've issued. So if you take the position that previously it's not everything you could talk about, but now your statement talks about everything that is being talked about now, how do you expect the public to perceive this, especially for the optics for you?
Dr. Alfred, you would agree with me that matters like Bawku with the happenings, there was no way we could have avoided that. If you follow up closely, Galamsey, since 2021 or so, even 2015, President Benson took his time. When it got intensified, I think just after election 2020. When we're in Bawku 2021, that was a main theme of the our president's speech, 2020 to 2023. So even last year in Kumasi, it was high on the agenda, and he actually said so many things. I came out to even say that he was so hard on the then president that he didn't even have a single reaction to all the things we said about, our president said about Galamsey in his speech. So it is not as if we are choosing and exercise selective as to what we want to talk about. Once it appears topical to us, you hear from us.
Well, so you're also exercising your discretion on what to speak about. I see. Anyway, but let's say, this position that GBA takes has generated a lot of reaction, and in fact, we have quite a number of them coming through thick and fast right now. Professor H. Kwesi Prempeh has also just posted something on this. Dennis, what's Professor H. Kwesi Prempeh saying?
Yes, so the man who is in charge of the constitutional review is also raising some questions about the GBA's resolution. So he asks, if the GBA believes that Article 146, as currently constructed, does not provide adequate protection for a target of removal petition in the post prima facie phase, its remedy lies in proposing appropriate amendments to that provision. Let me go back a bit. He starts off here by saying that how exactly is Article 296C supposed to apply to a suspension decision pursuant to Article 146? Is it the GBA's position that every time we read may in the Constitution, Article 296 is triggered? So if a provision says Parliament may do X or Y, Parliament must publish regulations under 296C prior to doing X or Y? Really? He continues, and he advances the argument and brings back the case of Ransford France as Leonard Senior Martin Pebu was talking about.
I see. And stay with me. Let that be on the screen. And Leonard Yakuji, if you can respond to this, let's put this Professor H. Kwesi Prempeh's position on it. In fact, which is consistent with what Martin Pebu has just stated about how exactly you expect 296C supposed to really, as it were, apply to the suspension decision pursuant to Article 146. Is it the GBA's position that every time we read may in the Constitution, then 296 must automatically sit in?
Not that. We think that this is looking at the special nature of this case, removal of the Chief Justice. That is why the Assembly thought that this should be one of the cases where 296 must be triggered. Because even though Ransford France says that if the regulations are not made, it doesn't make the act invalid. We think that this is one of the circumstances in which the regulations must be made. And don't forget, Ransford France says that it's not in all cases. We think that this should not fall into that exception, that it shouldn't be made. That is what the Assembly thought. And let me reiterate that even at that Assembly, there were valid opinions and positions on this matter. Just as It's done at every meeting. At the end of the day, there must be a position taken. And if that position is taken by the majority, everybody must take it.
Well, you acknowledge the dictates of 146 that this entire process must be in camera.
I agree with that.
But then you are making a demand that the president should publish the prima facie for all of us to see. Why is that?
Why is that? Because that stage has been gone with. So it's just like a proceedings in a case you are doing. Once the recordings have been done, because this matter will not go back to the Council of State again. They have finished their stage. So whatever proceedings that they have, decisions that they have, I think they can give it to whoever they want to give it to. But it is our right to make a request. It is their right to say that, look, we won't give it to you.
But your request,
premature to ask for them.
But your request must not be in oblivion. I mean, it must be predicated on something. That's why I ask you exactly what is this based on.
It's based on the fact that there's been a decision or there's been an advice that a prima facie case has been established. That is why the president took the next step by suspending the Chief Justice. So the request at the Assembly was that, okay, can you furnish us with the reasons constituting the establishment of the prima facie case against the Chief Justice relative to the petition?
Well, is this particular request having any legal basis or covering to the extent that, yes, GB acknowledges the process must be in camera, but then again, even before the facts, they make the demand that the details of prima facie should be made public for us all to see. Does that defeat the details of 146 in any way, shape, or form?
No, I mean, I don't see that one defeating 146 because, basically, because the prima facie stage has already been cleared, it means that as we speak, President Mahama, with the advice or on the advice of the Council of State, has a ruling. It is that ruling that concluded that the Chief Justice has a case to answer. That is, a prima facie has been made, so the 5-member committee should be set up. So it means that there is a document. In one word, what I mean is that there is a document lying down which has reviewed the whole case and said the case should go on to the substantive hearing. So it should be brought out for us to read. Remember, when Professor Akweku Asare petitioned for the removal of Chief Justice Tokono earlier on in December, and then in January, President Kufuor came out with the prima facie ruling. Yes, so it means that at least, and also you remember the Charlotte Osei matter, the findings of the committee, etc., came out. So far from our past, at least even the Kufuor one, January 2025, is an example that when prima facie was finished, it was released. Yes, so that one, and I'm sure President Mahama will do it because it doesn't help our democracy if citizens cannot access the prima facie ruling. Let's read it, digest it, and see what insights we get from it to guide our path or to guide our steps going forward. So the release of the prima facie ruling, that one, I'm in support that it will help.
I appreciate your time on this, and I also do thank you. This is just a beginning of a series of conversations we're going to be having. I thank you so much for joining us. Last Kuji, thank you for joining us on Ghana Tonight. And there's another statement that's just, in fact, this is a post, not a statement, because this is generating a lot of reaction. And what's the next? Apart from Professor Kwesi, who has been talking about this as well?
Well, so Learned Counsel Tadiosori also reacts to this particular resolution, and he particularly takes issue with the part of the resolution that talks about the reversal of the directive from the acting Chief Justice to have all cases brought to his office for assignment and listing. Mm-hmm. So he begins by even questioning the timing of the releases, i.e. the 26th resolution and then the 24th statement from the GGA, how to reconcile that. Now he comes to look at the specific demands that the GGA, I said GGA, forgive me.
Yeah, you're both a member of GGA and GBA.
Precisely.
It's okay.
So GBA. So he says that these demands are not only legally flawed and disrespectful, but they also expose a troubling inconsistency in the bar's reasoning. Just days ago, the bar issued a statement that now seemed at odds with its own resolution. That was what he tried to point out to the PR of the Ghana Bar Association, how they themselves had indicated that the issue was sub judice and how they wanted the process to be followed. And now they are saying that what the president has done is unconstitutional. Now it goes on to say that by law and long-standing practice, the power to assign cases is an administrative function of the Chief Justice. This function pertains to the office of the Chief Justice, not the individual currently holding the title.
Right.
He continues by saying, the bar's position implies that the powers of the office are personal to the suspended Chief Justice. But when she was in office, the bar raised no objection as she reassigned judges and altered case allocations. Article 14610 of the 1992 Constitution clearly states the President may, acting in accordance with the advice of the Council of State, suspend the Chief Justice, unquote. This means unless there is an advice from the Council of State, the President cannot suspend the Chief Justice. The word may here does not grant discretion to act unilaterally. Once advised by the Council of State, the President is constitutionally bound to act. He must suspend.
Right.
I mean, these are just excerpts of what he's been saying.
It's quite a long one.
And if you've been following Tade Osori, he takes issue with some of the things that the suspended Chief Justice has done by way of issuing administrative directives and then practice directions. And when you read, he reiterates the point that when he was raising those issues, he did not see the bar also come to comment on such matters.
And I think that's captured in the Protocol petition that was dismissed as well.
Precisely so.
By the former president, Anadoy Kufuor. Dennis Pobey Wadam Esquire is a member of the Ghana Bar Association, a member of the GJ as well. Thank you. And it's my producer. Appreciate you, as always.
Always a pleasure, Alfred, being here.
For a quick break, because the GBA statement is not just about the suspension. They captured a number of things that are of national concern. Galamsey as well is in there. We'll be back shortly after this quick break. We'll get into that aspect. We'll have a conversation. Stay with us.
Why are more and more professionals choosing Flamingo Paint?
Flamingo Paint has great hiding ability to cover and transform old walls easily with just one coat.
With just small paints, I think
Welcome back. This is Ghana Tonight. Now, coming up next, before we get into matters of illegal mining shortly, we also have an update on the ongoing mediation of the Bawku conflict. That's coming up next by Asantino Tufosei to the second, and we'll cross over shortly to the Ashanti Region, our Northern Bureau Chief and Chief Ashanti Regional Correspondent William Evansinkum is connecting with us. The videos you're seeing on the screen right now at the outskirts of the Menchia Palace, where there's crucial day one of the resumption of Tufosei to the second's led mediation talks in the Bawku conflict that took place earlier today, and that's what we're seeing right now. William Evansinkum is connecting with us on Zoom. William, this look like very encouraging videos of people who are out there supporting the entire process. But you were there at the Menchia Palace today. Tell me exactly how day one has been.
Well, so Utufo held separate meetings with the fielding parties. The first to appear before him was the delegation from Ampusi, whose engagement was very brief. Then, of course, an hour time or after, the delegation from Kusasi also came in to meet the Santehene. In fact, I spoke with some of the natives, from Bawku, and they expressed optimism that, the peace that they've been striving for, it is something that they will soon see happening as far as the Bawku issue is concerned. Tomorrow, the Santehene will be meeting the two parties. At this time, are not going to be separate meetings, but they will be coming together face to face before the mediation. Before Santehene, tomorrow they'll be meeting, or they will be coming together. Then on Thursday, they are also expected to come together. We do not have any information to the fact that there's going to be press briefing after Thursday's meeting. If there's going to be anything of that sort, maybe tomorrow we'll provide answers to that.
I see. Now, you mentioned the people you spoke to and how about security as well at the Menchia Palace? We saw a heavy deployment of the police there, but paint to us what you saw when you went there today.
Well, a security protocol was a top-notch one. Police, military patrolling the Menchia Palace, especially they were heavy around the Menchia Auditorium, where the mediation process was happening. Of course, the delegation also has some level of police military protection. And one thing that I also saw was the fact that everything was provided for them, including transportation from where they were lodged to the Menchia Palace. And there wasn't any breach as far as earlier security arrangement as we were made to were informed and proud to the peace talks was concerned. So it was a top-notch one.
I see. And then also talk about the people that you spoke to outside who were there to support the process. What were the expression and expectation that they told you?
Positive. They were positive. I quite remember I spoke to one Mampusi and one Kusasi, and they all expressed optimism that long road to peace will be a short one, because they have absolute confidence in Santehene that it is something that he's done. He's done it before during the Dagmon crisis. He came in and was able to at least calm the storm. They believe that similar thing will happen here. So by Thursday, they're expecting nothing short of lasting peace returned to Bawku.
I do appreciate your time on this, William, and I thank you so much for joining us. And this is just day one, William. And so tomorrow it continues, correct?
Absolutely. Tomorrow, the two parties are coming together. They are not coming their separate ways, as we saw today. Tomorrow, they are coming together, and maybe for the first time, they'll be facing each other.
I know you will be there for us, so we'll connect tomorrow as well.
Absolutely.
Have a good night.
Thank you.
William Evans Sinkum is our Northern Bureau Chief, and he leads our Central Regional Correspondence in there. Strong team on the ground. So tomorrow we will be there to update you every step of the way here on TV3 and across all media journal platforms. So stay with us. But on behalf of the rest of the team, we do thank you for staying with us here on Ghana Tonight. Tomorrow, we're also following this matter, as I told you earlier, on this excavators in the Ashanti region that the mayor, and indeed has been speaking to the KMA, has been explaining why some national security operatives stormed the Forestry Commission yard to try get these excavators. There's been something in the works. We understand that these excavators that were seized from illegal mining sites in the Ashanti region had already been used for some works by the mayor and indeed the Kumasi Metropolitan Assembly. So tomorrow we'll get some more details on this and get reactions as well for you and what the position of the law is about excavators that have been seized or impounded and what it should be used for. Stay with us. We'll be back tomorrow with some more conversation on this. Join the New Day team tomorrow morning on TV3 and the Sunrise 3 FM team on 92.7. On behalf of the rest of the team here on Ghana Tonight, we do appreciate your company. I am Alfred Ocansey. Have a good night.
Ghana Tonight is brought to you by